So, thanks everyone for joining us. Just a couple of things in case during the presentation you have any questions, please ask those questions in chat. I'll be compiling them and we'll take them up either during the presentation or most likely towards the end of that presentation. The Q&A is typically going to be off the record, so we'll stop recording by then. But I hope that we'll this presentation will help you understand how the amendment in the competition bill is likely to impact startups. We're going to talk about how mergers and acquisitions will be impacted. We'll talk about what are called killer acquisitions, which big tech companies do to essentially kill competition. I don't know if you remember, but a couple of months ago, or maybe sometime last year, there were emails related to, emails from Mark Zuckerberg, which were made available and included how his thinking about acquiring Instagram was, because it started becoming a competitor. So we know that there are many conversations around monopolies or oligopolies in the Indian market, and the Competition Commission is really not able to deal with them unless there is evidence of harm. But also, it's the CCI typically acts when there are complaints made. So hopefully through this conversation, where we're not going to go into too much legal stuff, but I hope in the Q&A, many of the lawyers who are present on this call will engage with us and with each other on some aspects of the bill. So I'm going to hand it over to Sarvesh for that presentation, and we'll have a conversation afterwards. Sarvesh?
Thanks, Nikhil. Hi, everyone. So today, roughly, we'll be going over, broadly, we'll be going over the impact of the competition bill on the various stakeholders and how the bill particularly addresses issues in digital markets. I won't spend too much time on this slide. To situate our conversation, what we've seen recently around the world is an increase in antitrust cases, and specifically with tech companies involved, the US, the UK, Europe, China, Japan, South Korea. In all these countries, we've seen investigations into Apple, Google, Facebook. And these are not just over one product or one service. It's just a couple of issues that are being tackled upon. I think the best example is yesterday we had the Reuters report, and it was a Tinder's complaint against Apple in India over App Store practices. And I'm going to use that complaint to just point out what the issues are in the competition issues and the complexity of addressing those issues in tech. So, for example, in the Apple case, there's already another investigation by CCI into Apple. And in that, Apple had argued that the relevant market that CCI should consider is the entire smartphone operating system market, in which Apple does not have a majority share because Android has 90% market share in India. So Apple isn't even dominant in that. So how can a case of dominance and abuse of dominance be registered against Apple? But the people who registered the complaint against Apple, they are arguing that the relevant market is not the entire smartphone operating system market, but the smartphone operating system market for iPhone. When you narrow it down that much, it's 100% monopoly of Apple because all iPhones run iOS. But which market do we choose? Which market should CCI choose? So we don't know that. So that's one concern. Then another example from the same case is Tinder had argued Uber does not have to pay commissions because even though it has its app on the App Store, the product delivery, that is the ride, happens outside in the physical world. So there are no commissions in that case. That's why Amazon is also exempt from commissions for the products that it sells through its app. So Tinder's argument is that our services, which is matchmaking, which is similar to what Uber is doing, matchmaking a rider and a driver. We are matchmaking people, and that also happens outside the online world. So why are we not getting any exemption? And then there are data concerns, how Apple is using data to build its own competing apps. So all these are new concerns that have emerged over the last 20 years. And this is a problem that's in digital markets. widely we are seeing that big tech is seen as dominant, but it's not considered harmful monopoly because in many cases it's not a monopoly, but like two companies having dominance. And in many cases, there are a lot of consumer welfare gains. So that's why the harmful aspect is missed out. But nevertheless, competition issues exist because we have other stakeholders who want to participate in the economy not being able to. And key features like network effects, switching costs, access to data, which and growth over profit. Many of these companies prefer growing over the regular profit model. So when you look at that, all these are new issues that we've seen over the last couple of years. Another thing about digital markets, it's time sensitive. We can't have CCI taking 2-3 years to decide if some company is being dominant and then decide if they should penalize that company, because by then that it already leads to irreversible harm. There's no scope after that for some other company to come and battle it because this company has already gained so much market share. So time is very crucial in digital markets. And the conduct is not just over one product. So while CCI might be investigating, for example, it might be investigating Google over search, but that ties into Google's advertising business. But CCI's order or CCI's investigation will be focused on what's happening in search. The data spillover effects, the network effects also affects other parts of Google. Then there's also, I already mentioned about the balancing of the welfare gained by the scope of harm. And then there's an issue of CCI having the understanding of technological issues, technological concepts to actually understand where there is an issue, where there is adverse effects, etc. So these are some of the issues, and some I'm going to like just go over a few cases in India, like major antitrust cases, and we'll see a trend in these cases where all these issues I talked about surface. So some of the major ones, Apple's App Store is under investigation based on a complaint filed last year, and the investigation began in December. Main allegations are how developers have to use Apple's own in-app purchase system, and then they have to pay a 30% commission in many cases. Then developers cannot communicate about outside sources of outside methods of payment with users. And criteria for why an app is being rejected is not clear. There's restrictions on third-party app stores on iPhone, and then Apple already has its own app, so sometimes these apps surface above other apps in App Store search results. So these are all complaints, allegations made against Apple. And similarly, we have Google, which is also charging high commissions, exclusivity, making smartphone manufacturers pre-install Google Pay and Google Play Store, even though there are some nuances between Apple and Google in that Google's Android devices allow you to have alternate Play Stores, but Play Store comes installed in the device. So by default, it becomes the most popular option. So is there really any competition there? Another interesting case is the WhatsApp case. So back in 2021, we had WhatsApp release a new privacy policy, and CCI initiated a suo motu investigation when this policy came out, because it was concerned that the WhatsApp's new policy allows it to share more data with Facebook. And this in turn enhances the dominance of Facebook. But then what happened? WhatsApp went arguing in the court that CCI does not have jurisdiction over data-related issues, and it cannot look into something that's already being looked by the courts. The court is also examining if this privacy policy is valid or not. Can it be valid or not? So these are the arguments WhatsApp made. But yesterday we had the Delhi High Court dismissed WhatsApp and Meta's pleas and allowed CCI to continue with its investigation. Then Amazon and Flipkart is another big case which has been going on for a while, and it was delayed until 2021 last year because of legal proceedings initiated by both Amazon and Flipkart. But issues that are being looked at there is how search algorithms of Amazon prefer certain sellers over others, and these sellers have connections to Amazon. So it's not just the issue with competition, but then there's FDI related issues. And how can CCI manage these two? These are all issues that we'll talk about a little later. Google News is another big antitrust case where it collects news and displays it in snippets and in the Google News tab from various digital media outlets, but digital media outlets are not getting paid a fair share of, they are claiming that they're not getting paid a fair share of their revenue, advertising revenue. So earlier last month, I think there was a Times of India report saying that the government is looking to bring in regulations to make these companies actually pay for news content. Swiggy and Zomato is another case where we are seeing something called bundling. So what the allegation here is restaurants want to use their own delivery services, but just have their products listed on Swiggy and Zomato. But Swiggy and Zomato want to bundle listing of food items and the delivery. So they want to handle the delivery because in their opinion, when they do that, it's better for consumers, as in they can control the time, they can control the quality of delivery, they can control, and they get more data points. So whatever reasons they might have, their argument is that it's better for consumers this way. But restaurants feel that they need to be able to directly deliver to consumers, get direct data about consumers. But platforms don't share that data. Platforms use that data to build their own private labels. So Swiggy has its own private label like Gold Company, which has found which are the popular products selling in which area, and then they start these labels which deliver it and which makes the products in cloud kitchens for a slightly cheaper rate. So, but this data is not available to the restaurants themselves. Another interesting case which was actually dismissed by CCI is against Uber, where Meru Cabs had filed a complaint against Uber's dominance in the ride-hailing. But the reasons it was dismissed are quite interesting, because CCI found that the market is highly competitive. Why? Because there's Ola also. So as long as there's Ola, as long as Ola is a significant threat to Uber, there's no question of dominance. And if there's no question of dominance, then there's no question of abuse of dominance. And an interesting point that CCI had made in that order was, maybe if Meru Cabs had filed a complaint against both Uber and Ola, then we have different grounds to investigate. But against just Uber, we can't do anything about it. So this is a problem we have across different segments in digital markets, right? E-commerce has two players, food delivery has two players. So, which means that it's not dominance in the traditional sense, but there's some kind of dominance. Now coming to, so these are all the various issues that the Competition Amendment Bill is trying to address, or at least was meant to address. And the bill was introduced in Lok Sabha on 5th August. And it's going to amend, it will be amending the Competition Act of 2002. A lot of the provisions in the bill are based on recommendations made by the Competition Law Review Committee, which had submitted its report in 2019. And as of now, the bill has been sent to the Standing Committee on Finance for examination, and there's a report expected within 3 months. Most likely, we're going to have the bill might be taken up in the winter session of the Parliament. Another front that CCI is working on to address digital issues is setting up a dedicated digital markets unit. This bill does not specifically have any mention of digital markets unit, but CCI's rulemaking powers are quite wide, which we'll see later. So maybe using those powers, it might be able to set up this digital markets unit. Moving on to the contents of the bill, mergers and acquisitions have been one of the most talked about aspect of the bill, because now any merger or acquisition which exceeds 2,000 crores or 250 million US dollars in deal value will require CCI approval. How is this different from what's currently happening? So right now we have a threshold based on assets or turnover. So there are different slabs in different ways, but roughly it's like if you're in India having 2,000 assets, over 2,000 crores in assets, or over 6,000 crores in turnover, then if you have to get approval from CCI for that deal. But what happened with this kind of threshold with assets and turnover is many deals got missed. For example, the most famous example is how Facebook acquired WhatsApp, and back in I'm not sure which year, but they acquired WhatsApp for $16 billion. And that deal did not require any CCI approval because WhatsApp did not meet that threshold criteria. So now CCI and other regulators around the world are thinking this deal might have been stopped because it has led to the dominance of Facebook, right? So this is the kind of deals that CCI now wants to cover. And the point here, so which ones, on who all will it apply? It has to be companies which have substantial business operations in India. And what this means will be defined by CCI at a later stage, but CCI chairperson had said that we'll be taking into consideration factors like number of users in India, amount of data collected, amount of payment received from the company making that investment. And there's also a new definition of control. So if to decide if an acquisition or a merger has happened, control is one of the ways CCI looks at it. And now control is being defined as any material influence over strategic affairs. So if there is any material influence, that means it's a combination. And I think an example that I can use to explain why this matters. For example, what's been happening, the whole dispute between Binance and WazirX, we have Binance claiming that they did not actually, even though there was some kind of acquisition announced back there was no actual transfer of equity. But then we have WazirX saying that Binance is controlling a lot of the processes on the WazirX app. Now, with this new definition, CCI might see it as Binance actually has gone ahead with the acquisition because it has some kind of control. So this is subjective. We don't yet know the material influence, how it's going to be found is not yet defined. So that's something we are waiting on. But these are some of the changes that we can see having an impact on cases like the WazirX Binance incident. Then talking more about this new deal value threshold. So now killer acquisitions are covered, as Nikhil had said before we started, and also the examples are given. But the question that we have now is, should we go after such deals? Will WhatsApp be where it is today without Facebook's help? WhatsApp was offering free messaging services. Will it have the amount of money to continue all these over the last couple of years if it did not get Facebook's funding? And more importantly, could CCI even sense that WhatsApp will become such an integral part of Facebook and Facebook will become dominant in 2022? So these are questions we don't have answers to. So if there are no answers, so should we go after such killer acquisition deals? And more importantly, how will this whole deal value threshold affect the startup ecosystem growth? Because a lot of the funding that we have for startups in India are from foreign investors, foreign investment management funds. So what's happening is, what they do is they look for attractive investments that they can exit quite quickly. They're not looking for, to stay in a company forever. They want to exit a company after they reach a certain point. But now, if there is a deal value threshold, it means if they want to sell their stake to someone else, they have to go through the entire process of getting CCI's approval. So this might deter investments by foreign investors into India. And in turn, this might reduce India's economic growth, employment that these startups offer. The new control definition again should worry startups because
just one other thing, Sarvesh, I was just thinking about this. It's not just going to impact foreign investments into startups, it will also impact Indian investors investing in startups. Because what happens is, typically when an investor, let's say, gets in at an angel or a seed level, they progressively sell their equity as it goes up. And so what happens is that something reaches a Series D or the Series E level, where the deal value is, say, multiple millions of dollars, close to. That's typically a Series E would be typically at a unicorn level. In those situations, if there is an acquisition, that acquisition that doesn't go through, how will investors exit except for an IPO? So that basically limits the upside for investors up to a particular level. And I think that's even at a local level right now, for example, where there's a lot of seed funding available, but there is very little at a Series B, C, and D, which is all dried up. That long-term sort of staggered exit might actually be impacted.
Yeah, true. Yeah, that's a valid point. I think like now we've seen a lot of activity in terms of domestic investors also investing in angel rounds, Series A, Series B. But historically, we've had a lot of foreign investors pouring more money. So anyway, moving on. So there's also another controversial aspect is, how do you define which that this 2,000 crore or 250 million US dollars is the deal value for a particular segment? Because if you look at the pharmaceutical industry, $250 million might not be a big amount. But if you could look at the tech industry, it might mean different. So where did CCI arrive at this figure, and why is it universal across all sectors? Another aspect that the bill aims to do is reduce the time limit that CCI takes to evaluate combinations, that is mergers and acquisitions approvals that has been submitted. So overall, now they have to evaluate everything within 150 days. So the way it works is they have to form a preliminary view within 20 days and then give, if there's no preliminary view, then the deal is considered as a green signal. But if they do have a preliminary view in 20 days, then the parties have to explain why CCI should not investigate further. But the overall process is expected to complete in 150 days. And moreover, even if CCI finds any objections, the two parties can submit modifications. They don't have to do an entire new proposal or notice. They can just submit modifications and have CCI approve those modifications. All these, I think, are beneficial because it helps startups. It gives quicker timelines for startups, and it also allows them an opportunity to address that rather than an outright rejection. The other aspect that the bill touches upon is anti-competitive agreements, and the way it does this is broadens the scope in a couple of ways. The most significant one is now hub and spoke cartels are covered. What are these? So there are two main kinds of anti-competitive agreements. One is horizontal. This is when there are agreements between players in the same sector. So for example, a car manufacturer works with another car manufacturer to fix prices of cars. So that's a horizontal agreement. And then we have vertical agreements where a car manufacturer asks a supplier who's down in the supply chain, and he has some kind of agreement with that motor, for example, the person who supplies motors for the car. So that's a vertical agreement. What's happening in horizontal agreement is sometimes there are third parties, for example, trade organizations, consultants, industry bodies. So these people facilitate an agreement, but they are not covered because they themselves are not part of that cartel. So what this bill does is it says, even if you facilitate an agreement, if you're one of those trade organizations which calls people together and you're the one who coordinates everything, you are now covered. So these are also considered, you're also considered a part of the cartel. Another major change is every provision for anti-competitive agreement now has the word services mentioned in it. So earlier it was like tie-in arrangement, as in two goods are tied, or refusal to deal of some goods. So now it's tie-in arrangement of goods or goods and services or services and services. So what this means is bundling will now be directly under scrutiny. So this is, I should point out that it's not, so CCI still went after services. It didn't like just ignore services because it was not mentioned in the thing, but now it's more clear. So that it leaves the legal ambiguity out of the picture here. So this will most likely be a boon when CCI is looking at bundling of two different services. The best example is when app stores, both the app stores say that if you want to be listed on our app store, you have to use our payment system. That's a bundling of service because you have to use the payment system if you want to be listed on one of the marketplaces. Same for Amazon and Flipkart. If you want to list on us, you have to use our logistics services. So these all might be now more explicitly covered. And also supply agreements, exclusive supply agreements has been rephrased as exclusive dealing agreements because now it doesn't just apply to buyers, but also sellers. So the example is Microsoft cannot prohibit vendors from selling Google products. Earlier, it could have been that it prohibits vendors from buying products from some other company other than Microsoft. Now, it also cannot bar them from selling products by other manufacturers or companies. When it comes to the appreciable adverse effects on competition, the competition bill has made suggesting two changes. One, to rephrase foreclosure of competition by hindering entry into market to foreclosure of competition. So what this does is it broadens the way CCI looks at AAEC, because now it's not just you won't be considered foreclosing competition if only if you like hinder entry, but any other means you use to foreclose competition will also be considered. And the second change is accrual of benefits has been rephrased as accrual of benefits or harm. So even if you're accruing benefits, but if you're also accruing harm, CCI will more directly now look into this. And this is very important for the digital sector because we'll get into a little bit more in the discussion, but this rephrasing will probably come to aid over there. The relevant market definitions have now been tweaked a bit because earlier it was a relevant market is considered a market comprising all products or services which are interchangeable by or substitutable by consumers. That was the earlier definition. Now they also take the supply side into consideration. So if the supplier is able to substitute between two products with relative ease, then they all fall in the same market. The example here is if a fruit seller can sell bananas today and can easily move to mangoes, then mangoes and bananas should be part of the same relevant market. And I think this makes sense, especially in digital markets, because changing supply in digital markets, for companies to change supply, it's relatively easier than goods market. because there are no physical products involved, it might be easier for you to repurpose your entire company's software engineering staff to do some other kind of product rather than the product that you're doing right now. And the relevant geographic market has also been tweaked a little. Now, what will be considered is the additionally will be considered this the cost that is associated with switching supply or demand to other areas. Again, this is going to be make a difference in digital markets, because for a tech company to offer an app in another city is relatively easier than for a manufacturer to start a set of factory or offer their products in another market. The penalties that the bill is now proposing is penalties now will also be consider income rather than just turnover. And I think this is a good thing for companies because turnover is usually a larger number than income. CCI will come out with exact regulations on which violation will result in which, but the overall it's being capped at 10% of the average of the turnover or income, depending on the violation. There's also an increase in penalty if you submit false information while seeking approvals. For example, if you submit misrepresent or leave out some details when seeking approvals, which I think is very important now because Amazon's CCI, Amazon has acquisition of future coupons. So CCI has put that on hold because Amazon had submitted misrepresented what happened. So in these kind of cases, there is a 5 crore penalty that will be applicable. Now both companies and the people in charge of the concerned function will be held liable for any violation, unless the person is able to prove that they did not have knowledge of what went wrong, or that they did all due diligence and still stuff went wrong. CCI can also impose lesser penalty. There's a section in the Competition Act, which allows CCI to impose lesser penalties. And one of the ways they can do that now, it's expanded the grounds on which they can do. For example, now, if parties disclose that they know about some other cartel, which they are not part of, but there's a cartel existing out there, so that the penalty on that party will be reduced. Another thing, another major improvement is you can also now give settlement offers to CCI, even if, so even during the stage of the investigation, you can give a commitment offer. And after there's an investigation report, you can give a settlement offer. And you can say that I'll make all these changes. Can this case go away? And I think this is a big incentive for companies because otherwise they get stuck in this lengthy legal process. They go appeal to NCLAT, then they go appeal to the Supreme Court. So all this can be avoided because companies and CCI can just talk to each other. Companies also can submit appeals, but here what is the condition is that you have to submit 25% of the amount of penalty that CCI has imposed before you appeal to NCLAT, which is in a way prompt companies to like scrutinize their decision because that 25% is foregone if the NCLAT decides to not accept the appeal. In terms of what the changes have been proposed for Competition Commission of India, Competition Commission of India now has the power to appoint the Director General with the prior approval from the center. Earlier, this was directly like the Director General was directly appointed by the Ministry of Corporate Affairs after consulting CCI. Now CCI has, in a way, the precedence in appointing the DG. And why this matters is because, in a way, it gives CCI excessive powers to shape the future of companies and industries. Now CCI, I think the best quote, Rahul Rai, is a competition lawyer. He said that this would mean that CCI is now the judge, jury, and executioner. It can decide cases, and it can paint a report, and it can decide the correctness of that report. The report part was painted by the DG, who was in a way distanced earlier from the CCI. CCI and the selection committee now have to also have the members of the CCI and the selection committee, which appoints the members. Both of them now have to have experience in technology. So that's another criteria, which is a welcome change because, as we pointed out earlier, they have to be able to understand the nuances of the tech industry to investigate these cases. Another power that CCI now has is it can sign MOUs or agreements with other government bodies. Why this matters? So right now, if you look at Amazon, what's happening with Amazon, we also have not just CCI looking into Amazon, we have the Enforcement Directorate looking into Amazon for alleged violations of FDA regulations. But we do not know how much information sharing happens between ED and CCI. So the bill now allows CCI to like sign agreements with other statutory bodies and find out for exchange of information or other case material. And there's also now more grounds under which statutory authorities can request investigation. So not only if, so if some other entity, for example, the RBI finds an issue, they can request CCI to investigate a company, not just for anything it thinks violates the Competition Act, but for anything it thinks even deters the objectives of the Competition Act. So the objectives of the Competition Act are to promote competition, to increase consumer welfare. So if any of these, the RBI thinks that a company is violating, it can ask CCI to investigate, which is just broadened what other entities can ask CCI of. When it comes to the DG's new powers, so the Director General can now ask companies to produce very broadly all information and give all kinds of assistance. And it can even seek information from those not under investigation if it thinks that, for example, Amazon and Flipkart are under investigation, but if it thinks that some other company has information related to that, it can summon information from them as well. And it can keep all this information for 180 days. And after that 180 days, there's a provision which allows it to extend that by 30 days and extend that by 30 days. So in a way, it can keep this information perpetually if it needs to. And that raises a lot of concerns because we do not know how safe this is. We had this issue of a DG report leaking, I think with one of the cases in which Google was involved, and Google took it to the Delhi High Court or Supreme Court, arguing that the DG shouldn't have leaked the information because there's a lot of confidential data present in that. So if the DG now can practically keep the data forever, we do not know how the data is going to be kept safe. The DG can also order for seizure of information, and it can ask police in any state and the central government to assist them in any inquiry. And when it comes to regulatory aspects, CCI's rule-making powers have again been increased. It can determine, as I said earlier, what the criteria is for to establish if a business has substantial operations. Then it can decide the amount of penalty for violations, the time and manner for how mergers and acquisitions have to be filed, and how when companies have to give responses if CCI issues a notice, and how it will determine whether to use a turnover-based penalty or income, and how this turnover and income should be calculated. But whenever CCI issues any of these regulations, the bill now says that CCI has to publish draft regulations, and it has to seek public comments on that before, and it has to publish whatever public comments it has received. So all these are welcome changes, I think, in terms of the transparency. When it comes to the government's powers, the government can issue notifications when it comes to determining what the value of assets or turnover or the deal value for the combinations and for example, now it's $250 million or 2,000 crores, but this can change if the government issues another notification. You can also determine when two companies are considered group entities, the percentage of ownership that one company has, which will essentially classify it as a group entity. That's about it for the presentations, but I think there are more questions than what I've covered, because which we'll get into the discussion part. So over to you, Nikhil.
Thanks, Sarvesh. I was just wondering if there are any questions that you might have. I think we can stop the recording now, please.